Okay, folks, let's go ahead and get started. Thank you all very much for being here this evening. My name is Gregory Bowman, and I have the honor and privilege of serving as the Dean of the West Virginia University College of Law. And on behalf of the College of Law, it is my pleasure to welcome you to the 25th Annual Charles L. Ihlenfeld Lecture, a lecture that is devoted to the timeless and the critically important issues of ethics and public service. These lectures are made possible by a generous gift from Charles L. Ihlenfeld's will, and his gift to our College of Law allows us to bring to campus outstanding speakers to remind all of us of what Mr. Ihlenfeld modeled during his life: ethical conduct and public service. Mr. Ihlenfeld was a prominent West Virginian who practiced law for more than 56 years and was also a devoted public servant who contributed to his community in many ways. He loved the city of Wheeling, West Virginia, and he served as a member of the Wheeling City Council from 1959 to 1967 and served as its mayor from 1963 until 1967. He served as the chairman of the West Liberty State College Foundation and of the Wheeling Creek Watershed Commission. His public service encompassed positions at both the state and the federal levels. He served as prosecuting attorney for Ohio County from 1940 to 48 and as a U.S. magistrate judge for the Northern District of West Virginia from 1971 to 1979. In addition to being active in his community, Mr. Ihlenfeld was also active in the legal profession. He was a 1933 graduate of the West Virginia University College of Law and was a lifelong supporter of the college. He served as president of the Ohio County Bar Association, and he was an active member in both the West Virginia State Bar and the American Bar Association. For more than half a century then, Mr. Ihlenfeld was known and appreciated by the community in which he lived and worked as a thoughtful, caring, diligent attorney of great ability. And he was revered as an attorney and a citizen who adhered to the highest ethical standards. So it is fitting that this lecture series at the College of Law honors a career and a life marked by significant and substantial contributions to the legal profession and memorializes a person whose life was distinguished by service to his country, to his state, to his community. We deeply appreciate the fact that the Ihlenfeld family continues to be so supportive of this lecture series. As I've already noted, Mr. Ihlenfeld was a 1933 graduate of our College of Law. His son, Bill Ihlenfeld, is a 1965 graduate of our College of Law, and his grandson, Bill Ihlenfeld II, is a 1997 graduate of our College of Law and recently completed his term of public service to our state and our nation as the U.S. Attorney for the Northern District of West Virginia. Both Bill Ihlenfeld and his son, Bill Ihlenfeld II, are here today. Would you please stand and be recognized? It really is quite meaningful that we have such close ties with the legal community and that we have this ongoing relationship with the Ihlenfeld family. And this lecture is a very important part of the annual life of our law school. So thank you again very much for your continued interest in and support of the College of Law and this lecture series that bears your name. It is now my privilege to turn the podium over to my colleague, Joshua Frichet, who is the College of Law's Associate Dean for Research and Faculty Development. Josh?
Thank you, Dean Bowman. Thank you to Margaret and James, Ken, and others on our incredible staff here who helped put this event together. And another sincere thank you to the Ihlenfeld family for making these events possible. Your support of the College of Law is truly appreciated. I'm pleased to have this opportunity to introduce you to our speaker, Adam Swensek, a New Orleans native. He was the valedictorian of his class at Boston University, earning a degree in journalism. Like me and the other Dean Frichet, he is a graduate of Tulane Law School, where he was a senior associate editor of the Tulane Law Review and a member of the Moot Court Board. Adam began his career as a commercial litigator at a leading New Orleans law firm and then left to enter public service. He now serves as the Chief Deputy City Attorney for the City of New Orleans, where he oversees the city's appellate division and serves as lead trial counsel in many of the city's highest profile civil disputes. From 2015 to 2017, he successfully defended the city's efforts to remove 4 Confederate monuments from public display, winning both a trial level and an appeal at the United States Fifth Circuit Court of Appeals and the Louisiana Supreme Court. The focus of the Ihlenfeld lecture focuses on public service and ethics, and I'm thrilled that Adam has agreed to share his experiences with us today, and I'm just as thrilled that his employer has allowed him to do that. It's not often we get to have a close insight on such a high-profile case so close to a ruling like this. As lawyers, we are often called into challenging situations related to emotional topics that present difficult policy questions and thorny legal issues. Adam's experiences over the last 2 years certainly confirms that reality. Please help me welcome Adam Swensek.
Good evening, everyone. I would like to thank Dean Bowman and the West Virginia University Faculty and Administration for allowing me the opportunity to be here this evening. I would be remiss if I didn't also acknowledge the Ihlenfeld family, not only for their financial support of this lecture series, but also for several generations of public service, which is an issue that hits very close to home for me. I would be wowed by the attendance here tonight had Dean Furché not informed me that attendance is compulsory for 1Ls and that many of you are here entirely against your will. So instead of thank you, I will beg your pardon. If I can't make my speech interesting, I will at least endeavor to make it lengthy. I'm here this evening because a little over 2 years ago, long before this issue burst onto the public scene with the violence in Charlottesville, Virginia, the city of New Orleans voted to remove 4 of its Confederate monuments from public display. That decision sparked a massive public debate in New Orleans and resulted in almost 2 years of litigation in which I was lucky enough to land a role defending the city. This spring, after multiple legal challenges, we prevailed in the courts, and shortly thereafter, we took down monuments to Confederate General Robert E. Lee, Confederate President Jefferson Davis, General Pierre Gustave Toutant Beauregard. Can you guess which one was from Louisiana? And a truly bizarre monument that honored something called the Battle of Liberty Place, which was an 1874 insurrection in which a group of former Confederate soldiers, a paramilitary group styling itself as the White League, seized control of city government and ultimately paved the way for the end of Reconstruction in New Orleans and much of the South. Because I am a lawyer, and because most of you will be lawyers, I think it is appropriate to begin my talk on Confederate monuments by doing something that lawyers do best, which is offer up a big fat disclaimer. My first disclaimer is that I am here this evening as a private citizen and not as a public servant. My statements don't necessarily reflect the opinions of the mayor at whose pleasure I serve or the city council members whose laws I am often called upon to uphold. My job is to defend the city's laws, not to make its policies. And when you represent a governmental entity, the policy at stake often varies depending upon which particular legislator you ask. So, while I will endeavor to confine myself tonight to the facts, it is possible that 1 or 2 or 10 opinions may slip out, and if it does, I apologize. And if it later turns out that something I say here is inconsistent with a position I am later called upon to make in court, I would like the record to reflect that I'm completely drunk right now. The second disclaimer is that I am not here to judge or to condemn or to preach or to in any way say anything negative about people who may disagree with me about the wisdom of taking down monuments. People I respect very much disagree with me about taking down monuments, including one of my best friends whose dog is named after General Beauregard. Also my cousin Bobby, who recently introduced me at a party as the one destroying our history. Now, I personally, I think we did the right thing, taking down the monuments we did when we did, how we did. But that moral clarity didn't come to me overnight. It took months of reflection and analysis and talking to people and thinking about these issues, because these policy questions, they are profoundly difficult and challenging, and they can leave even the most open-minded person conflicted. A person's feelings about race, about history, they evolve, they change, which is why I think it is important to listen with an open mind and an open heart, and to take seriously the arguments of people whose viewpoints conflict with our own. When I give talks to lawyers about professionalism, I often preach never to impugn the motives or the character of those who oppose you. Demonizing others rarely helps you win your case, and it never helps you win respect in the legal community. We're right to condemn those who murdered people in Charlottesville, but we also cannot let the worst among us hijack reasonable dialogue. To shut down debate, to brand an entire viewpoint as racist or untenable simply because it is held by some who are racist and who are untenable, is ultimately, in my mind, unproductive and intellectually dishonest. And with those disclaimers out of the way, let me get back to my effort to make you all into liberal, bleeding heart snowflakes like myself. To understand our monuments debate, I think it is helpful to understand a little bit about New Orleans, my hometown. We have a population of about 400,000 people. Like many southern cities, we are a very, very blue island in a very, very red state. We are majority minority, about 2/3 black with a smattering of Vietnamese communities and Latino communities. The remainder, about 1/3, is white. Our mayor is a white Democrat in his second of 2 allowable terms. Our city council, all Democrats. Everyone's a Democrat in New Orleans. It's just how Democrat are you? Our city council is majority black. We are known worldwide as the Big Easy, as a place where people come to have a good time. Places like Austin, Texas, they have to make an intentional municipal commitment to keeping it weird. We just sort of do it naturally. To give you an idea of who we are as a people, a couple of years ago in early May, a section of an underground tunnel downtown collapsed, and it created a massive sinkhole in the middle of one of our busiest commercial streets. And in most places, this would be a cause for alarm. There would be a declaration of emergency, there would be voter outrage, there would be an inquiry, heads would roll, there would be a citywide assessment of threats. In New Orleans, we threw a party. As I said, it was early May, the weather was nice. The sinkhole happened to coincide with Mexican independence, so hundreds of my fellow citizens armed themselves with pitchers of margaritas, went downtown and celebrated Sinkhole de Mayo. Not kidding. This is what happens when you let people drink on the street. They become ungovernable. New Orleans was founded in 1718 by French explorers on the first available stretch of land in an otherwise unhospitable swamp near the mouth of the Mississippi River. It became part of the United States in 1804 when Thomas Jefferson purchased the middle third of the country from France. In 1861, when Louisiana and her sister states broke away from the Union, New Orleans was one of the largest and wealthiest cities in the United States. That wealth was generated largely through the sale of sugar, tobacco, and most importantly, cotton, products that were generated through slave labor. New Orleanians enriched themselves not only by trading in the commodities that were produced by slaves, but in slaves themselves. The city was the site of the largest slave market on the continent. Hundreds of thousands of people were bought and sold on the docks of the river and sent upriver to work fields all over the South. Now, I don't want to get preachy, but slavery today seems like an abstraction. It's one of those things we talk about, and it doesn't mean much. And some mornings I ride my bike to a part of the French Quarter that's still residential, and when it's quiet and it's beautiful, it's easy to forget that 2 blocks away, 150 years ago, there was a slave pen where 50 to 100 people at a given time were put on display for would-be purchasers, like you'd see at a Chrysler lot today. It still catches me off guard today, even now, when I find myself researching some arcane point of Louisiana property law on Westlaw, and I stumble across a really helpful case only to figure out that the property in question is human chattel, which is a coldly antiseptic term for a person. Practice tip: if you are writing a brief, do not rely heavily on a case featuring slaves. Being that New Orleans was founded by the French, that it was governed by laws we inherited from the French, and that it was filled with people speaking French, it should surprise none of you that when the Civil War broke out, we almost immediately surrendered. We were captured by Northern forces in 1862, and we remained in Union hands through the balance of the war through 1865. Now, if you watch the movie Lincoln, which did much better in the theater than the actual Lincoln, you know... Sorry, too soon. You know that Reconstruction started off well. The states passed the 13th Amendment, and in Louisiana, that actually translated into meaningful change. Louisiana elected an African-American governor in the 1870s. There were some integrated schools during that time. Things went downhill after the Battle of Liberty Place. The South proceeded to systematically disenfranchise African Americans through legal mechanisms like literacy tests and poll taxes. It also mandated the separation of the races into grossly unequal facilities. In Louisiana's defense, we at least ratified the 13th, 14th, and 15th Amendments. Anybody want to guess when Mississippi formally ratified the 13th Amendment abolishing slavery? Well, you ruined my point. So 1995, they finally got around to forwarding it to the National Archivist in 2013. That's Mississippi. West Virginia and Louisiana need to be grateful to Mississippi because they keep us firmly at 48 and 49 on whatever list gets published. Now, race is a complex thing. And I don't want to give you the impression that New Orleans is some place that's poised on the cusp of racial conflict. In fact, I think that we're a place where black folks and white folks get along in a harmony that is unmatched in a lot of the places you'll find in the South, and certainly in more enlightened places like Boston or in cities like Detroit, where the races are as segregated as anywhere you'll find. I think maybe it's that racial tension takes too much effort, or maybe that our city's greatest cultural accomplishments like jazz and our food and our music reflect the contributions of a lot of different cultures. We can see something ourselves in ideas and values we share. The ease with which we get along in New Orleans sometimes makes it easy to forget that New Orleans is still in the heart of Dixie. It's where Homer Plessy was arrested for riding in a white rail car, resulting in the infamous Supreme Court decision that blessed the separate but equal doctrine. If you went to New Orleans today, you could meet a lady named Ruby Bridges Hall. She's a very sweet 63-year-old woman who in 1960 integrated New Orleans public schools flanked by federal marshals. And she spent her entire first grade year learning in a classroom by herself because all of the other God-fearing white New Orleans mothers took their kids out of school. Like it or not, race and historical injustice aren't easily forgotten. They bubble beneath the surface, and they inform many political decisions in southern cities and in southern states. The great southern writer William Faulkner, I think, put this idea better than anyone has. He wrote, "The past is never dead. It is not even past." Which brings us to the summer of 2015 when a 21-year-old named Dylan Roof walked into an African-American church in Charleston, South Carolina, and murdered 9 unarmed people at a prayer service. His writings, which surfaced online along with pictures of him holding a Confederate flag and other symbols associated with white supremacy groups suggested that he was trying to start a race war. Thankfully, he didn't, but he did reignite or incite a reinvigorated debate about the abundance of Confederate images and symbolism that exists throughout our country and in particular in the South. And I'm not talking about stars and bars on a truck bumper in Tuscaloosa. That happens. I'm talking about symbols sanctioned and sanctified by the state. Until the roof shooting, the Confederate battle flag flew above the South Carolina State House. When I walked into the Fifth Circuit Court of Appeals to argue this case, I walked past the state flag of Mississippi, which currently has the Confederate battle flag located where the blue field and the white stars are in the American flag. Look at the list of official state holidays in Louisiana, and you will see that January 19th is still Robert E. Lee Day, and that June 3rd is still Confederate Memorial Day. I think it would be exceedingly reductive to suggest that Dylan Roof is responsible for the debate over Confederate flags or Confederate monuments. That gives him too much credit and not enough credit to those who have been fighting about this issue for decades. But the Charleston shooting did give, I think, a newfound sense of purpose and of moral clarity to those who believed it was time to re-examine whether these symbols, which have, like it or not, become closely linked and associated with white supremacy, have a place in 21st century America, particularly atop our public buildings and in our most public places. Are they history or are they hate? Or if they're both, what do we do about it? In New Orleans, what we did about it was to target 4 of our most prominent monuments. Now, the Lee Monument, Davis, Beauregard, and Liberty Place Monument were installed between about 1885 and 1915, which coincided with the absolute low point of African American political power in the city of New Orleans. They were installed at the heyday of the Jim Crow era by all-white leaders who were elected by all-white voters. And they were installed in public, high-profile places to send the message that the South remained unbowed and unapologetic in defeat. Robert E. Lee was positioned facing north, looking down our most beautiful street, St. Charles Avenue, because they wanted to send the message that he would never turn his back on his enemies. General Beauregard, his statue features only his dates of service in the Confederate Army, and he's wearing a Confederate uniform. Now, the Liberty Place Monument is unbelievable. It bears an inscription that was added in 1932 that celebrates the role of the battle in ending Reconstruction and literally says, it restored white supremacy to our state. It's a quote from the side of the monument. It says, white supremacy on the side of the monument. The Chamber of Commerce loved it. Now, this may be an appropriate place to address right out one of the biggest arguments you hear from people who oppose removing monuments. And again, I respect many who do. And the argument goes along the line of, well, where do we stop? If you take down Robert E. Lee, don't we have to blast Thomas Jefferson and George Washington off Mount Rushmore because they owned slaves? Don't we have to take Andrew Jackson off the $20 bill because he was involved in Indian removal? Don't we have to do all those things? No, we don't. I mean, we could. It would be within our power. Congress could take down the Washington Monument because Washington owned slaves, but it doesn't have to. There's no legal requirement, and I can draw a pretty good bright line for you. Number 1, did you take up arms against the United States sometime in the 1860s so that you could form a slaveholding confederacy? If yes, did someone put up a statue of you for that reason? It isn't rocket science. Now, to be fair, there are those in my city who would absolutely take down any monument to any slaveholder who would change the name of Tulane University because Paul Tulane helped fund the Confederate cause. I don't have an opinion on that view. But to my mind, and I want to be clear that I don't know, I've not checked with the mayor on this or the city council, I think you can articulate a difference between a monument to white supremacy and a monument to a person who by our current standards is a white supremacist. And I think this difference may impose a retaining wall that prevents the slippery slope from becoming an avalanche. And I guess what I'm saying is that you could persuasively argue that the appropriate policy inquiry is in evaluating our monuments is that we need to look to why these monuments were erected, why the people are being honored, as opposed to whether we can articulate something dishonorable. The monument to Andrew Jackson at the site of the Battle of New Orleans is very different if you took the same monument and you put it on an Indian reservation in Oklahoma. Very different reasons. Now in our city there is an ordinance, City Code Section 146-611, and it governs the removal of monuments from public display. At the request of any elector or on its own motion, the city council can institute proceedings to have a monument or in this case, declared a nuisance, and the city council may mandate its removal. The city council is required to get the reports and advice from a number of different city officials, the city attorney. There also has to be a series of public meetings with agencies responsible for anti-discrimination issues, for historical preservation matters. The city council takes all of this information in and it holds another public meeting. In our case, there were two. And the city council has to decide three things. One, whether the monument is inconsistent with notions of equal protection. Two, whether the location at which the monument is located has been or may become the site of violence or of criminal damage to property. Three, whether the cost of maintaining the monument outweigh the cultural and aesthetic benefits of keeping the monument. Now, as a legal matter, this ordinance is weird because the city council has inherent authority to install or remove whatever city property it wants. If it wants to compel that we take down a tree or remove a trash can, it doesn't have to hold a hearing to declare those things nuisances. And I don't see why a monument is any different. And I don't know why the city council would ever enact an ordinance that imposed on itself procedural limitations of this kind, but curiously, no one asked my opinion on this matter. Nevertheless, the city council followed the requirements of 146-611. There were meetings before all manner of bodies. There were packed houses. The Vieux Carré Commission, which has jurisdiction over the French Quarter, considered it. Historic District Landmarks Commission, the Human Relations Commission, and the city council had two different meetings. There were 6 hours of public comment from people for, against the monuments. All viewpoints were represented. It was about as public a process as you can imagine. And on December 17th, 2015, the city council voted to remove all 4. Sitting here today, it is difficult for me to convey to you adequately what a big news story this was in New Orleans when it was going on. I've lived in New Orleans almost my entire life, and other than Hurricane Katrina, and maybe when the Saints won the Super Bowl in 2009, it was I can't think of a story that received more coverage ever. It was in the news every day, in print and broadcast media. We'd file a brief and it would get reported on. The online comment section of our local paper, which is literally the worst and most racist place in the world, would often include thousands of comments for and against. These public meetings were held before packed houses. If you walked into a coffee shop or a restaurant, people were talking about it. Cab drivers were talking about it. And there were numerous public protests, some violent. The contractor we initially hired to remove them had to resign because his wife and children got scared of all the death threats they got. When we walked into the hearing, we did so with a police escort. It was intense. Now, I think it's fair to say that we expected to get sued about taking down the monuments. Folks in New Orleans are litigious the way folks in Salt Lake City are religious. It's what we do. Getting sued is almost part of the legislative process for us. I expected the lawsuit. I don't know that I expected how fast it would happen. 4 hours after the law was passed, 4 hours, several historical preservation organizations and a chapter of the Sons of Confederate Veterans filed a lawsuit in federal court seeking to block removal and to get a declaratory judgment that the monuments had to remain in place forever. The complaint was about 51 pages, 118 paragraphs of factual allegations and legal allegations, and they asserted 12 different causes of action or theories of recovery, and they said that they were denied due process in violation of the 14th Amendment, that their First Amendment rights had been violated because they could no longer express support for the Confederacy in the way they wanted, that they were denied equal protection because they were treated differently from those who supported removal, that we had taken their property in violation of the Fifth Amendment, that we'd violated historical preservation laws. It goes on and on and on. Now, plaintiffs sought a preliminary injunction that would prevent us from doing anything until the court ruled on the ultimate merits of our case. And this is very common in cases where you have a challenge to a law. Those of you paying attention to what's going on with the immigration debate right now, that's the stage at which we are. A preliminary injunction basically proceeds like a mini little trial at the very outset of the case. And in our case, it happened about a month after suit was filed. Sometimes it can happen in as little as 2 or 3 days. A preliminary injunction is critically important in a case like this because it's the court's first opportunity to really see the kind of advocate you are, and it gets its first glimpse at what your legal position will be. And the grant or denial of a preliminary injunction often serves as a kind of bellwether for the rest of your trial. Cases frequently settle, depending upon what the court decides, and this is because part of what the court has to consider in deciding whether to grant a preliminary injunction is the extent to which the litigant has demonstrated a likelihood of success on the merits. Now, the sad part of my speech is that when the story gets to the part that I was involved in, it becomes a whole lot less interesting. Lawyers have a way of ruining everything and taking all the fun out of life. And that's certainly the case here. Everything that made the policy arguments interesting suddenly disappeared, and the case oftentimes can degenerate into a very technical or nuanced arguments that normal people really don't understand or care about. And that was certainly the case here. Hundreds of people showed up to our hearings, particularly the preliminary injunction hearing, and I think what they expected to hear was a clash of cultures, these big important issues of race and history, and you know, both the district court and the Fifth Circuit Court of Appeals created overflow rooms where people could get live audio feed and feel like they were in the courthouse, and what they got treated to was probably the most boring thing in the world. Because what the case ultimately ended up being about was whether the plaintiffs, by virtue of caring for the monuments, by taking care of them, by cleaning them, created or acquired a constitutionally protected property interest by virtue of an obscure Roman concept called negotiorum gestio, which is codified in our state civil code. I actually bored myself saying that. Suffice to say, since I am here talking to you and not the lawyers for the Monumental Task Committee, which filed the lawsuit, the district court did agree with us. And in fairness, they had a tough argument, right? If you can put it up, you can take it down. That's what it boiled down to. It denied the preliminary injunction. It went point by point through the plaintiff's claims and found that they really hadn't demonstrated a likelihood of succeeding on any of them. It also found that they hadn't proven that they were going to suffer any kind of irreparable harm if we removed the monuments. And there's more that I can say about that, but I don't want to get too in the weeds. I know that I'm the last thing between you and Monday Night Football. If you are truly interested, I would encourage you to read Judge Barbier's opinion in the Monumental Task Committee case. It's at 157 F Sup 3rd, 573. That opinion was ultimately affirmed by the Fifth Circuit, which declined to pass on the wisdom of removing monuments, but nevertheless agreed that we had followed a fair and open process. That decision paved the way for the rest. Instead of boring you in our time remaining with the details of the litigation, let me bore you instead with a couple things that I took away from this case that maybe will be valuable to you if you ever find yourself in a case like this. And number one, when you do have a case that turns on a highly controversial policy, sometimes it's best not to make the case at all about the policy itself. When you've got a polarizing issue like abortion or gay marriage, people usually have their minds made up about the underlying moral issue or policy question long before the case ever goes to court. And once someone's mind's made up, you're not going to change it, particularly in the confines in which lawyers operate. You're never going to write a 25-page brief or make a 20-minute oral argument in which you convince someone that the right to life outweighs the right to choose. You can't. You'll never win that case, and you don't even have to make it. So instead of focusing on the wisdom of removing the monuments, which is fraught with differences of opinion, we tried to make every brief, every argument about whether the city could remove monuments. That's an easier case. It's common sense. If you can put them up, you can take them down. Whether you think that removing monuments destroys history, or whether you think it rectifies a historical wrong, it was made, that decision was made, by a democratically elected leadership as part of a very public process that unfolded in accordance with law. Judges love the rule of law. It makes them happy. A judge does not want to sift through moral ambiguity or make tough policy calls. It's not their role. They would rather uphold a fairly and democratically determined outcome. Approaching controversial topics in this way also makes an advocate's job easier. You don't have to prove that you're right to win. You just have to prove that you're rational. It's an easier case. Now, having said that, there is a place in the law and in advocacy for pointing out that you're doing the right thing. You shouldn't hide or you shouldn't apologize for your policy, because judges also like to do the right thing. And so while I didn't make policy the centerpiece of the argument, I think an effective litigator can and should try and show why the legally correct outcome is also the just outcome. And one way to do this, practically, is by enlisting the help of those who are most affected by your decisions to file amicus briefs in support of your case. In the monuments case, we were contacted by representatives from the Urban League, which wanted to help. And I said to the lawyer who represented the Urban League, I'm going to file a brief that says why we can, and I really think the court would like to hear from you about why we should. And ultimately, they submitted a great brief with some really good policy arguments that hit on the social and equitable issues, and the people who made that are the ones to whom those issues mattered most. Now, another way of highlighting the equity of your position is simply by highlighting the ways in which your opponent is unjust. Now, in the monuments case, I think my opponent made a strategic mistake by making every argument that could be made. In my experience, and there's different schools of thought on this, 3 good arguments, well made, pack more punch than throwing everything against the wall and hoping that something will stick. Too many arguments dulls the impact of your good ones, and it makes you look grasping. And I think the plaintiffs made a particularly poor choice in claiming that the city violated their right to equal protection by removing a statue that said white supremacy on the side. If you know anything about why the 14th Amendment was passed, and federal judges do, their clerks do, I think this argument comes off really, really tone deaf and I think arguably immoral. And we called them out on it. And the first line from the merits section of our brief, quote, "Plaintiffs argue without a wisp of shame or irony that removing memorials to the Confederacy violates the Equal Protection Clause, a law enacted to protect the civil liberties of former slaves." I didn't need to insult my opponent to make them look bad. We just had to hold up a mirror. My second takeaway, I hope you will indulge me in just a tiny bit of navel gazing. If I were to tell you that I expected to find myself at this point in my career handling a case like this, or that I knew exactly what I was doing at every stage of this case, I would be absolutely lying to you. I've been a lawyer for 11 years, which probably sounds incredibly old to many of you, and probably means that I should know what I'm doing, but none of us knows what we're doing, if we're being honest. In my head, I am a kid, I'm a 1L, I'm sitting in Civ Pro, trying to figure out what in the heck is happening to me. And as this case unfolded, and it became clear how big it was and how much it mattered to people, and as it became obvious that this was a case we had to win, I was completely terrified. Because there were like 4 30-plus-year lawyers on the other side, and I'm like, how am I in charge for the city? I'm like a man-child. I think it's funny when they talk about duty in a tort case. I'm a kid. I kept looking around, hoping that someone would come and rescue me. No one did, and I got through it. And whether you're ready for it or not, a lawyer becomes responsible for his client's legal problems, and that often means his or her client's lives on the first day of the job. Your clients aren't going to care that you're nervous or that you're making it up as you go along. They will see you as a grown-up, regardless of how you might see yourself. This is a huge obligation because it means you don't necessarily get years to figure out what you're doing, but it's also a huge opportunity. Sarah Weddington had been out of law school for 4 years when she successfully argued Roe v. Wade. Justice Thurgood Marshall was 32 when he successfully argued his first case before the Supreme Court for the NAACP. Also know that the most seasoned attorney on the other side is scared too. No one is prepared to get real-time tweeted from the jury box. Which brings me to today and the close of my remarks. It's been about 6 months since we removed our monuments, and I think it's a little bit too soon to try and assess what that means for New Orleans or what it portends for the future. And I'm not so naive as to think that we've solved all our problems. Inequity persists. A cynic, I can be cynical, might say that the removal of our monuments was just a symbolic gesture, and to the cynic, I would say, of course it was. What is a monument if not a symbolic gesture? A physical manifestation of our beliefs and our ideas at one moment in time. And symbols matter. We know this because people are willing to kill each other to keep them up, which may be the best policy argument I can make for why they had to come down. Our city turns 300 next year, and we now have 4 vacant spaces to fill with symbols that embody who we are today. And I think that it is this process in which healing can occur. General Lee's pedestal in Lee Circle is currently empty. Some have suggested Spike Lee, Bruce Lee, as possible diversity candidates. I am partial to Sarah Lee. Whatever we ultimately decide, however, I am most proud of the fact that we all get to decide, which is something that I can't say about the ones we took down. And I think that's progress. And I will stop here and answer any questions you may have.
the idea was advanced that while monuments, such as before you cite, can be taken down from public spaces, because they are part of the history of a city, a state, a nation, they should go somewhere for people to contemplate them in their now, shall we say, diminished condition. Where did the monuments in New Orleans go?
So that is a fair point, and one of the points that we tried to make in the litigation is that we didn't tear them down. That would have been far cheaper and far easier, and I think raised far more troubling questions about how we confront history. The current plan, and it's an evolving thing, and so I don't know exactly where they are going, is to try and put the monuments in a, we don't yet know, but possibilities that have been discussed include a Civil War park where they can be viewed in proper context, and we can, there can be explanatory materials. There has been some discussion about relocating the General Beauregard Monument to one of the cemeteries in our city where General Beauregard is buried, which seems to be in a more appropriate way to deal with it, because the monuments themselves, they are historically significant, not just because of their history in 1884 as embodiments of cult of the lost cause, but because of what we've done now. And I think that not only are they historically significant items, they are indeed artistically beautiful ones. The Beauregard Monument, it's huge. It's the size of a Tyrannosaurus Rex. Not kidding, it's the size of a Tyrannosaurus Rex, but it's a beautiful monument. And so I don't think that there was any of us, certainly none of the folks that I had occasion to talk to, stomach the idea of let's destroy public art. So I think the desire is to try and relocate them to just not in our most prominent places. And I think the act of simply relocating them, the symbolic gesture of removing them, was important. Anyone else? Okay, I guess I said it all, right?
I too am a layperson. I come from the same department as that gentleman, music. But I'm curious if you could talk a little bit about applications of nuisance law, how it was applied here. And I'm thinking particularly of a case up the road from you all in Nashville. There's a fairly controversial monument to Nathan Bedford Forrest, founder of the Ku Klux Klan, that's located on private property but within eyesight of the interstate. I was curious if you could maybe talk a little bit about how nuisance law may or may not apply there as well.
Certainly. So there are a couple of wrinkles, and it's always exciting. Thank you for that question. It's exciting to get into the law part of it. One thing that makes Tennessee different is, number one, there's a state law in Tennessee that prohibits or sort of governs the relocation of Civil War era monuments. We don't have that in Louisiana. There was an attempt to try and enact one, and I think had there been, we would have had a decent argument for dealing with it for reasons I won't go into. Nuisance is a strange choice of words for the city council to have used in its ordinance, because there is a common law idea of nuisance, though we don't have common law, we're civil law. There's a well-codified nuisance jurisprudence, and generally nuisance relates to the interactions of private property owners vis-a-vis one another. I have only so much freedom to use my property. There is some point at which my exercise of my freedoms impinges upon your exercise of your freedoms, and nuisance attempts to try and provide some kind of meaningful way to regulate that tension of competing property owners. I don't think that this is a true nuisance case, because this is the city regulating its own property. And even though we use the word nuisance, we have defined what a nuisance is. And in fact, I think you could make an argument that had the city council said, because it has plenary authority to regulate its own property, had it passed an ordinance that said, our earlier ordinance 146-611 be damned, we would like to remove the General Robert E. Lee statue without doing what that says, I think I could have made a good argument that that's enforceable, because one legislature can repeal either expressly or by implication what another legislature has done. But the reason that nuisance, true nuisance really doesn't come into play is because this is our property and we are not the sovereign trying to regulate private property. Hope I answered that in 1,000 words.
Hello, I guess that makes me a layperson too, because I'm not a lawyer. I'm a nurse, and was part of a discussion on the campus, not where these fellows were, but somewhere else, on the Health Science Center recently, talking about the issues after Charlottesville. And while you really crafted your argument well for not focusing on race in order to make your argument in a court of law, how do we draw it back to race? And what would be your strategies or tactics to win, not necessarily win, but to forward the agenda in the court of public opinion? And I don't know if you feel prepared to answer that, but I'd really appreciate it because your story's so interesting, and I really appreciate you for being here. So
Well, and I just want to make sure I understand, because I don't know that I'd rather answer your question than not, but give me a little more. What do you mean?
Well, for example, we took questions in advance that a panel discussion could hopefully talk about in terms of diversity issues and how our campus was sort of reeling after Charlottesville and how people felt here. And we had questions everywhere from, please don't destroy our history, to, do you know where the Civil War monuments are in West Virginia? Which, of course, I don't. I know there's a monument in my neighborhood that's erected to the first white person born in this state, which I'm sure a lot of people have no idea about. But it was just really striking, the questions, and that people were, this fear that somehow, you know, people who might be different than us, or the lens that we view people through, is just very...
Well, one thing I will say is that I don't know that I need to do anything, or that anyone in the South really needs to do anything to interject race into a particular issue. I think it has a way of interjecting itself, and as I said, it bubbles beneath many of the things that inform many of our policy issues. I think that's part of it. I think we are blessed to have a fairly diverse. We have a majority black city council. We have a very diverse leadership, and I think that, I will say today, moving forward, the decisions that we make are made with a lot of different people at the table, and there's no, so I guess, and I don't know if I'm answering your question, I just think that in moving forward, I'm confident that just we will have enough people at the table that issue, I hope, will take care of itself, and if it doesn't, I'm confident that we will hear about it.
Thank you. Again, it was very interesting.
Thank you. Thank you.